of the court, I, Nur Nadia Rahmat, appear for the applicant Wong Shee. Appearing for the respondent is my learned friend Nur Sheila Bujang.
Good morning, Council. This matter concerns Wong Shee against Government of Malaysia, LLB20603. The petitioner has filed a petition in the Federal Court or exclusive original jurisdiction, challenging the constitutional validity of Section 63 and Section 64 of the Anti-Money Laundering, Anti-Terrorism Financing and Proceeds of Unlawful Activities Act 2001. The petitioner seeks declaration that those provisions are invalid because they are inconsistent with Articles 5 and Article 8 of the Federal Constitution. The central issue before this court is whether the petition truly falls within the narrow jurisdiction under Article 4 Clause 3 and Article 4 Clause 4 of the Federal Constitution, or whether it is in substance of a matter that ought to be brought before the High Court first.
My Lord, the petitioner's view is that if Parliament enacts a law which violates constitutional rights, then that law should not be treated as valid merely because it was legislated under an existing statute. The constitutional violation is so serious that it should fall within this court's original jurisdiction. My Lord, the petitioner submits that the Section 63 and 64 of the Act 2001 are unconstitutional because they impose a double presumption that is unfair and unreasonable. These provisions deprive the petitioner of the presumptions of innocence and treat him differently from others in a similar situation, thereby offending Article 5 and 8 of the Federal Constitution. The petitioner says that the effect of these provisions is severe. They impact ongoing criminal forfeiture proceedings and create an unjust burden on the petitioner. A law that interferes so directly with their personal liberty and equality must be subjected to strict constitutional scrutiny. My Lord, the petitioner further submits that this is not a mere technical objection. It concerns the validity of the statutory provisions that directly affect constitutional rights. Since the challenge involves the Constitution itself, the Federal Court should hear the matter and determine whether these provisions are valid.
Council, the petition is framed as a challenge based on Article 5 and Article 8. Why should this not be treated as an inconsistency challenge instead of an incompetency challenge?
My Lord, the petitioner's view is that if Parliament enacts a law which violates constitutional rights, then that law should not be treated as valid merely because it was legislated under an existing statute. The constitutional violation is so serious that it should fall within this court's original jurisdiction.
But Article 4 Clause 3 is limited to cases where Parliament and state legislature had no power to make the law alone. Are you saying that is the basis of the petition?
My Lord, the petitioner says that because the provisions are unconstitutional in substance, the court should treat the challenge, as one going to legislative competence as well.
May it please the court, the respondent submit that its petition is incompetent. It is not a true incompetency challenge on Article 4, Clause 3, but rather an inconsistency challenge based on Article 5 and 8 of the Federal Constitution. That means the matter does not fall within the federal court's exclusive original jurisdiction. The Constitution draws a clear distinction. A petition under Article 4 Clause 3 is only available where the complaint is that Parliament had no power to make the law. Here, the petitioner does not say that Parliament lacked the power to enact Section 63 and 64 under the Federalist. Instead, the petitioner says the provisions violate right of Part 2 of the Constitution. There is a different kind of challenge and must be brought in the High Court first. The Federal Court in this case explained that all incompetency challenges are inconsistency challenge in a broader sense, but not all inconsistency challenge are incompetency challenge. The petitioner complaints falls into the broader category only. For that reason, leave ought not to have been granted in the first place. The respondent further submits that the court had the inherent power to revisit the grant of leave if it is found that the jurisdictional requirements were not specified. Since this petition does not meet the requirement of Article 4 Clause 3, the leave order should be set aside and the petition struck out.
Counsel, does the court have a power to revisit leave after it has already been granted?
Yes, my lord. The court may revisit leave if it later becomes clear that jurisdiction was absent from the outset. Leave cannot create jurisdiction where none exists.
And why is this distinction important?
Because the federal court's original jurisdiction is narrow and should be strictly construed. If every constitutional challenge were allowed to come directly here, it will undermine the constitutional structure and deprive litigants of the ordinary route through the High Court.
Counsel, for the respondent, let me press you further. If we accept your argument, does it mean that any challenge based on fundamental liberties under Part 2 can never be brought directly before this court?
My lord, not never, but only in very limited circumstances. The constitutional scheme clearly attains that most fundamental right challenge begin in the High Court, where evidence can be properly tested and factual metrics established.
So, are you saying that the federal court is not the appropriate fact-finding forum?
Precisely, my lord. The federal court's role under Article 4 Clause 3 is not to conduct trials or examine dispute facts, but to determine pure question of legislative competence. In contrast, this petition involved evaluating the effect of the law on the petitioner rights, which is inherently fact-sensitive.
But what if the alleged violation is apparent on the face of the statute?
Even then, my lord, the proper road remains the High Court. The constitutional structure is deliberate. It ensures the cases are filtered and developed through the judicial hierarchy before reaching this apex court.
Okay, counsel, let me challenge that. Suppose a law is clearly oppressive and unconstitutional on its face, would require the petitioner to go through the High Court, not delay the justice?
My lord, while there may be delay, the rule of law requires adherence to proper procedure. Jurisdiction is not a matter of convenience. If this court begins to bypass jurisdictional limits for the sake of this expedience, it risks undermining the constitutional framework itself.
You place a significant weight on the procedural discipline.
Yes, my lord, because jurisdiction is foundational. Without jurisdiction, any decision, even if correct on the merits, will be legally unsustainable.
My lord, the petitioner respectfully submits that this is not a merely technical jurisdictional issue. The provision in question has direct constitutional consequences, and the court should not allow substance to be defeated by form. The petitioner asks that the matter be heard on its merits.
With respect, my lord, jurisdiction cannot be expanded by the importance of the issue. Even serious constitutional complaints must be brought in the proper forum. This petition should not proceed further in this court.
I have considered the petition, the submission of both parties, and the legal framework governing the federal court's exclusive original jurisdiction. The court finds that this petition is in substance and inconsistency challenge disguised as an incompetency challenge. The petitioner's complaint is based on Article 5 and Article 8 of the Federal Constitution, and it does not allege that Parliament had no power to enact Section 63 and Section 64 of the Amlat Law 2001. Article 4 Clause 3 is limited to challenges based on legislative incompetency. This petition does not satisfy that requirement. The proper forum for such a constitutional challenge is that the High Court in the first instance. The courts further hold that leave to file the petition ought to not have been granted. The grant of leave does not itself confer jurisdiction. When jurisdiction is absent, this court is entitled to set aside the leave order. Accordingly, the leave order dated 5 January 2022 is set aside, and the petition is struck out. Costs will follow the event.
This case illustrates a key constitutional principle in Malaysian law. Not all constitutional challenges belong in the federal court. The distinction between legislative incompetency and constitutional inconsistency determine the proper forum. Failure to follow this structure may result in the case being struck out even before the merits are heard.